Is the Constitution just an outdated document? After all, the left says it was written by white aristocratic slave owners. Is that true? This is our conversation today on Vantage Point.
Vantage Point is brought to you by American Vision. For more information on today's show, check out God and Government, the 3-volume series by Gary DeMar. You will find it at AmericanVision.com.
On my right, Gary DeMar, Speaker, President of American Vision. On my left, Republican-bashing, Constitution-hating, author and speaker, Joel McDermott.
Couldn't have said it better myself.
Okay. The Republicans have taken over Congress, at least on the House side. The Senate right now, there's a bit of rebellion on the Senate side. The moderates under Harry Reid want a little bit of compromise. The left, they want no compromise at all. One of the things that the Senate has decided, or at least the Congress has decided to do, is to get up and read the Constitution. And they said that they've come in here as constitutionalists, and therefore they want to know. In fact, what's funny about all this is they've all been taking an oath to uphold the Constitution. Mm-hmm. The very fact that they have to get up there and read it is an indication that my guess is they're pretty ignorant of the Constitution. But there were a couple of articles that I thought were interesting about all this. Washington Post's Ezra Klein lamented that the Constitution is confusing. He says it was written more than 100 years ago. Well, it was written more than 200 years ago. And the Constitution really isn't that confusing. In fact, it's one of those rare documents where you actually have minutes of the debates going on about the Constitution. I mean, there's a lot of clarity in it, even though the courts have messed up with all that. So one person says the Constitution is confusing. Another one says that the Constitution is a Tea Party's fetish. We don't want to get too much into what a person means by that. Essentially saying, and from that they're saying, and it really doesn't matter. The Constitution doesn't mean anything. It's only what the courts decide. And Joe, I know we'll talk about this when we get back to this. That the 1803 Marbury versus Madison decision essentially has nullified the Constitution. The Constitution is what the judges say it is. Mm-hmm. And there is another one about the idea that, so the Republicans are going to get up and they're going to read the Constitution. But what about that pro-slavery, demeaning comment in the Constitution that blacks are only 3/5 of a person? I mean, they're going to get up in the well and say that. I mean, how racist is that statement written in the Constitution? We can talk a little bit about what that comment actually means.
Can't that be amended legally, though?
What's that?
It was amended legally.
Yeah, that's what I'm saying. I mean, that's all part of the process. You don't discard the Constitution. You amend
well, exactly. It. What's interesting about the Constitution, it is a document that our forefathers were. They saw the future well enough to know that not everything they were saying in the 18th century would stand. And they said, look, there's an amendment process. If you want to amend the Constitution, you can amend the Constitution. In fact, there were originally only 10 amendments. Now there are many, many more. You want to change something in the Constitution? You can change it. It's difficult to do that. Mm-hmm. But that 3/5 clause has nothing to do with the personhood of slaves or blacks. It was to deal with the issue of representation. A representative represented 30,000 people. The more people you had, the more representatives you had. We're beginning to see in this particular, with the census, is what's happened. Some states are losing representatives. Texas, Florida, and I think even Georgia is going to gain. The reason is they're going to gain because their population has gone up. The number of representatives stay the same. Well, the southern states wanted to count blacks. That would have given them more representation. Northern states didn't want to count blacks. In fact, the northern state says, well, since blacks are property, we in the North want to count our property as well. We want to count our horses and so forth and so on.
So much for
not
being racist.
Right. And well, the point was the North didn't want to count them. The South wanted to count them fully. The compromise was to only count them as 3/5. diluting the voting strength of the South. So it was actually a way to constitutionally get rid of slavery. If the anti-slavery states had gotten their way, I believe we could have gotten rid of slavery constitutionally.
Well, it would have happened peacefully eventually. We're the only nation in the world that required a civil war to allegedly end slavery. But the whole point is moot anyway. The Constitution is not just the original document by itself and the Bill of Rights, the first 10 amendments. It's all the amendments subsequent to that, to the Constitution. And that includes the 13th Amendment, which outlawed slavery. 13, that was at 13, right? The 16th Amendment, which gave citizenship to everyone born in American soil, including retroactively all slaves. So you're balking, they're making an issue, trying to play the race card once again. They're balking at reading part of the Constitution and not even mentioning that subsequent aspects of the Constitution completely obliterate that anyway. So it doesn't matter. It shows the good progressive aspect of our history, although granted, parts of the 16th Amendment are terrible, but objectionable, at least from our point of view. But the slavery issue is really moot, and they're just playing the race card once again. And in doing so, really playing on the ignorance of people who would be swayed by that argument, not knowing what else is in the Constitution to begin with. So they're hoping that the American people will remain stupid as to the Constitution.
Public schools, that may happen.
And in fact, they themselves may not even know, because they probably haven't read the Constitution.
And we're not, and I'm certainly not saying that the Republicans have been constitutionalists. They haven't been. And them getting up and reading the Constitution, some of them may sit back and say, "Boy, I didn't know that was in the Constitution." Yeah. And one of the other things that the Republicans want to do is to say every bill that comes through, you have to attach a constitutional provision that says this falls under this particular aspect of the Constitution. This is what makes this particular bill constitutional. Well, they're not going to do that. The Republicans aren't going to do it either. We are so deep in an unconstitutional government that it will take maybe the downfall of our government, I don't know, to get us back on solid footing again. But we are, just take, for example, that general welfare clause. I mean, that thing has been stretched like silly putty to be made to mean anything. Yeah. And yet when you read Madison's remarks, he says, look, that phrase ends with a semicolon, and then there's a definition of what constitutes general welfare. Today, general welfare can mean anything that anybody believes is for the welfare of the United States. But of course, general welfare today is really particular welfare. We're taking money, we're going to give it to this particular group. General welfare applies to everybody generally. So both sides have a problem with the Constitution. We'll just see if this Congress does any better getting back to some of the specifics in the Constitution.
Well, really, yeah, I'll be very interested to see when these guys stand up and make a show of reading the Constitution, whether they actually intend to adhere to it at all. Because they haven't, and it's been the Republican side of the aisle that hasn't historically. Now, granted, the Democrats have been much worse in doing it, but the Republicans never did either. And in fact, the so-called Party of Lincoln, Lincoln opposed the Constitution in 1865, well, in 1860 already, when he was trying to get, basically tried to suspend habeas corpus, I believe was the case, or at least some certain writs. Anyway, there were cases filed in the Supreme Court. The judge sent a federal marshal. He ruled against Lincoln. He sent a federal marshal to serve the writs, and Lincoln opposed him with the army. And so you have a case here where the court is being opposed by the executive by force of power, and it was the force of power, it was the centralized control of the army that determined who got to say what the law was. That's probably the only case in a long time where the Supreme Court didn't have the final say. But the tyranny goes all the way back, and the guy mentioned it in the article, it goes all the way back to Marbury versus Madison, and really before that, it was planned. The General Welfare Clause was written vaguely for that purpose. Madison may have argued in the Federalist that it is delineated by what follows in definitions, but he didn't mean it. And he was the most ambitious, even more than Hamilton, I think, in writing that stuff out to begin with, giving these broad general powers of taxation of general welfare, the necessary and proper clause. Congress can make all laws necessary and proper to carry these things out. Well, I mean, all the people who were opposed to the Constitution in the early days were all over this stuff. They said that the courts is going to become a tyranny, the Congress is going to become a tyranny, executive power is going to become a tyranny. They were crying it out. They were publishing 3-1 against the articles, against the Federalist Papers, throughout the newspapers all through the Northeast and the South too, saying this is going to happen. And it happened in 1803 when Marbury versus Madison was decided, in which basically the case was thrown out of court, but Marshall said, well, just in case it did come to my court, here's what I would have decided. And the reason I'm going on about this is because there's an interesting letter here written from Thomas Jefferson to Judge Johnson, who was, I believe at the time, a district court judge. And in this letter to Jefferson, the judge was asking for opinions on this case that had been decided by Marshall, the Cohens versus State of Virginia, basically allowed the Washington, D.C. to make laws within a state, enforce laws within a state, and the state could say nothing about it. Anyway, this is what Jefferson had to write. He said, this practice of Judge Marshall of traveling out his case to prescribe what the law would be in a moot case not before the court is very irregular and very censurable. And he explains what happened to him with Marbury versus Madison, and he concludes saying this, yet this case of Marbury and Madison is continually cited by bench and bar as if it were settled law, without any animadversion on its being merely an obiter dissertation of the Chief Justice. So he didn't even regard it as law. He just thought it was Justice Marshall's opinion. And yet today it's thrown about as if this was the great doctrine of judicial review.
And I think the reason for this is very simple. Look, it absolves Congress from having to make tough decisions. Mm-hmm. And then you end up controlling the colleges, the universities, the law schools, which means you then control the judges. Mm-hmm. And so you can subvert any constitutional provision just by doing it through the courts. We're seeing this on a constant basis. This is why, as Gary North likes to say, you can't change just one thing.
Right.
So many things have to change in our culture today. First of all, getting out of the mire of ignorance about what things say and what's going on, and also to get back to this decentralized government, which is something that we here at American Vision are attempting to do.
That's the issue. The centralizing of power in the court was planned. It was a conscious plan by particularly Hamilton, Madison involved also, and Marshall. But the way to get back to it is local control, and the question is, how do we get back there? And that's what we're working on here in the near future.
Okay. We are wrapped up for today.
That's right. Send your questions to vantagepoint@americanvision.org. Also, leave your comments on our Facebook page or our YouTube channel. Thank you for joining us.
For more information on today's show, check out God and Government. In this 3-book series, Gary DeMar introduces you to America's true history, discussing the influence of Christianity upon the founding and development of America. He presents a practical approach to developing a biblical perspective of the elements of society, challenging us to re-implement the values and priorities that made America great. Its factual documentation makes it ideal for Christians seeking to discover the truth of America's heritage. You will find this great work at AmericanVision.com.
How can the Constitution be a fetish? I just love the Constitution.
Actually, you don't.